The verdict makes her one of Britain's worst ever female serial killers. Well, Nick Freeman is a highly experienced criminal barrister, and he joins me now. Nick, thank you very much indeed for joining me. Your thoughts on how this case has been handled?
Well, it's been extremely complex. The offences were committed between June 2015 and June 2016. Complaints were made by medical teams fairly early on, as early as October 2015, and they were ignored. There was then a police investigation. She was suspended. She was ironically put in care in charge of a safety unit. And the hospital bosses seems to have tried to, I won't say bury it, but not give it give the complaints the sort of response that they should have had. They didn't investigate it properly. They didn't look at it properly. And these were senior doctors who actually expressed their concerns. There was then a 2-year police investigation, very thorough investigation, which has culminated in charges. And we've now had one of the longest murder trials that there's ever been. And the jury have been out for, I think, a total of almost 3 weeks, and the verdicts have been delivered in batches in 3 separate batches, which is not unusual. When they've been out for a certain time, a judge will call them in and say, you know, is there any prospect of you reaching a verdict upon which you're all agreed? And it proceeds on that basis. They say, yes, we have, and they then advise the judge which verdicts they've returned, and it proceeds on that basis. So it's been a very full investigation, a complex investigation. I don't think it's finished yet, because the Crown have now asked for a 28-day period to decide whether they wish to pursue 6 other charges, which have already been tried, but the jury haven't said not guilty. What they've said is we're unable to return a majority verdict. So the Crown need to look at that and decide whether they feel there is a reasonable prospect of success. If they feel that there is more than a 50% chance of success, they will ask for a retrial, and that retrial will take place at some time in the future. Of course, it's then difficult to find a jury who will not be, that everyone literally in the country will be aware of what's happened, and the jury will be advised to try and put matters out of their mind and just concentrate on the evidence that's been presented if they decide to go down that road. It's dependent upon the state of evidence. And that's obviously for the Crown to assess, but the Crown prosecutor together with the CPS, and they'll work out whether or not, clearly it's in the public interest, so it's simply a case of, do we feel there's a reasonable prospect of success, more than a 50% chance of success in securing verdicts. So that basically is a snapshot of what's happened. There inevitably will be a public inquiry, you know, that's going to take some considerable time. The warning signs were there at an embryonic stage, and astonishingly, they seem to have been ignored. And I'm sure that will be uncovered during the public inquiry.
And of course, for the jury, this has been a very difficult, turbulent time for them, a very big emotional roller coaster. I was talking to Helen Fields earlier as well. When you look at the full indictment, there were 22 counts, and they went through every single count separately. Now, Lucy Letby wasn't found guilty of all of those counts, and that shows, I suppose, the detail that the jury went through all of these indictments through all of these counts. What strikes you about this?
They've done a fantastic job. They've gone through the evidence as directed by the judge, as directed by the lawyers. They've applied their mind, concentrated on the evidence and nothing else. And in relation to the verdicts they've returned, they've basically said, we're sure beyond reasonable doubt that either the defendant is guilty, or I think in relation to 2 of the charges, she's not guilty. So that this is a case which illustrates the nature of the jury service and how good and well equipped they are when advised by a judge to deal with cases of this sort. But it's extremely difficult for them. They did start off as 12 jurors, and 1 had to retire before the jury retired. 1, for very good personal reasons, had to retire, so they were left with 11. And at some stage, the judge said that he would accept a verdict of 10. If 10 were unanimous, then he would accept that as a verdict. And in other words, it was a majority decision that he was prepared to accept. but it illustrates the perfect nature of a jury. In other words, you're being tried by your fellow peers. This was a very detailed, complex case involving complex evidence that relates to the defendant. There was a lot of circumstantial evidence as opposed to direct evidence, and what they had to do was consider that evidence in relation to each specific charge. And I think the fact that they returned 2 not guilty verdicts illustrates how carefully they've gone through that process.
And Lucy Letby actually wasn't there for the verdict being passed down. Were you surprised by that?
I wasn't surprised, and I do have to say, and I think myself and many other lawyers have said in the past, that there shouldn't be a choice by the defendant when the defendant decides to present him or herself to court, either for sentencing or for verdicts. In my view, that they have justice needs to be seen to be done, and that relates to all parties: the defendant, the victim, the families of the victim, etc., etc. And it shouldn't be a decision that defendants are allowed to make. In my view, the law needs to be changed. It needs to be changed quickly so that defendants are forced to attend court to hear all aspects that the judge feels it's appropriate for them to hear. If they decide they don't want to give evidence and they don't wish to come to court at that point, well, then that's a matter for a judge. But my view is, if people are charged with criminal offences, they should be forced to attend and listen to the evidence. If they don't want to defend themselves, they want to give evidence, they can sit in the dock and remain quiet, and they have to be there for sentencing, for the return of the verdicts and for sentencing. I don't think it should be the defendant's choice. I think that is a major weakness, and I think it doesn't give perfect closure, particularly for the parents of the deceased, these poor children who were murdered or attempted to be murdered. Some parents would like to have had the opportunity of looking at Lucy Letby in the eye and just bringing about some degree of closure for them. And by her refusal to go into the dock, she's depriving them of that, and that should not be her choice, in my view.
And I think that sentiment will resonate around the country. Very quickly, if we may, just moving on to sentencing, what do you believe the sentence will be?
I think inevitably a whole life tariff will be imposed. It relates to defendants over 21. I think she's 33. It relates to the most serious type of cases. This clearly falls within that. These are the most vulnerable types of people. There's been a huge abuse of trust, sadistic evil that is hard to imagine. And then running the type of defense, trying to blame it on people who are only seeking to do good and protect children, it is really a particularly appalling defense to run, in my view. So I think inevitably she will receive a whole life tariff, and I don't think she'll be surprised about that. And I think the judge has already indicated that's something that he's going to consider. And should I say, there are very few people in the country who actually receive that. But in this case, I think that's the appropriate sentence.